This is a work in progress. I just decided to talk about West Virginia's family law restraining order bill. Now I'm going to talk about the domestic violence statute. I've written about it. You can get the actual citation to the statute easily enough. But it's got 5 components. Domestic violence is either inflicting harm upon another person intentionally, or threatening to inflict harm, or, and I don't know which one this fits into, but harming family pets, threatening to harm family pets, damaging or destroying property in the presence of the victim. All of these things can be found to be domestic violence, mostly because they put the person under threat that they're next, that they're going to be harmed. I once had a family law judge who said that tapping one's high school ring with the big lump of gold on the side could be a perfect basis for a domestic violence filing if that bump matched up with a spot on the spouse's chin or jaw that had been used to break her jaw the year before. That's all it would take to keep her in line, just tapping the ring like this. So it can be somewhat subtle, blocking a person so they cannot move their car out of the driveway or so they cannot get out of the living room. Sexual abuse, obviously. And then there's sort of a catch-all of a combination of behavior that places the other person's health or safety at risk, such as bothering someone constantly. In the other video, I used the example of the woman that kept harassing her ex-husband, trying to get him to come back to her, knowing he was afflicted with leukemia and very, very weak. And I believe actually had that been filed as a domestic violence, it might have passed, but it is the one that caused the appealable decision and our decision to go ahead and do that family law protection order bill. That bill needs a lawsuit pending, either a divorce action, contempt, modification, an allocation of parental rights, which used to be called paternity suits. There has to be a case pending. But in regard to the domestic violence, it is the case. It's not a criminal charge. It's quasi-criminal because once it's in effect, a direct violation of it can end up resulting in incarceration. If the person is there at the house of the victim after the order has entered, the police are definitely authorized to arrest at that point. So if you've got one of those things, you still probably need to call a lawyer, although there are entities like Hope Incorporated, what used to be called also in our county Upshur of Women's Aid in Crisis, and there was a crisis center in Elkins. I trust it's still there. And they do a good job of guiding a victim through the process, letting them know the essentials of what has to be alleged. However, a lot of domestic violence tend to get filed when someone's afraid the other person's going to perhaps withhold the children in a custody fight or something like that. That really is not domestic violence, but it tends to be groomed and put into place. The sad thing is when someone comes in and is just given the forms and they fill it out and they don't realize what the statute says, so they don't know how to conform the facts that they've got into a statute. A domestic violence, a protective order can be 90 or 180 days. I think I heard recently it could be as much as a year, but it can be renewed if requested, and certainly can be reissued if additional behavior takes place. The trouble with that, and I recently had a debate with a judge, and you always lose debates with judges. That's why they're judges. I believe that once the order is in place forbidding any contact between the two parties, that a reaching out by the victim in an effort to get the accused person to respond is contempt of court for trying to cause a violation of the order. she respectfully disagreed with me, but I think there's plenty of logic for that. And I've had this time and again where once they've got my client in the place and they've put him in his place, then they text him and reach out to him, calling him names or bawling him out for not sending child support, sort of defeating their claim that they're terrified of this evil person. But I try to get my clients not to respond to such things. These days, if my client is facing criminal charges on the same set of facts, say a domestic assault or battery, I will either try to continue the case or even have my client go ahead and allow the order to be entered against him. In one case, there's a pregnancy, but there's no baby, there's no visitation that can take place. And in that particular instance, discretion being the better part of valor, it was just better to allow the order to be entered. Once the case concludes, the person's right to have access and ownership of firearms is restored, but a domestic violence criminal conviction, a misdemeanor with incarceration of up to 1 year as a possible penalty, that's permanent. You lose your gun rights after that permanently. And that's the one that probably has to be contested and the dice rolled to see if the state can carry its burden. I don't defend those criminal cases anymore, but I do collaborate with the person's criminal defense lawyer. That's the end of the subject, domestic violence. Give us a call if you have questions.